Hello everyone! Today we are going to be talking about the seat of arbitration. So stay tuned, we go straight into the matter in 2 seconds. Okay, we are going to be talking about the seat of arbitration. Why is it important, the seat of arbitration? When should we start talking and thinking about the seat of arbitration? Well, much earlier than the arbitration. We should start thinking about the seat when we draft the contract whereby we undertake to go to arbitration in the event of any dispute arising out of the contract that we are signing. Very important, arbitration is rooted on the parties' agreement, the contractual agreement to arbitrate. Judges from any country get their power from the state. Arbitrators, we do not, so it's very important when we draft those arbitration clauses. We will probably prepare another video on good and bad arbitration clauses. For now, it's sufficient that we know that there are a number of elements in any arbitration clause, the number of arbitrators, whether the arbitration is institutional or ad hoc without an institution, the law of the seat of arbitration that we are going to plug in. So very important to think about all these elements. But why is the seat important? The seat is very important because it sets the frame for the process itself. For example, if we have, and you will understand better what we are talking about, if we have an ICC arbitration in Paris, this could be what everyone thinks that is possible because the main office of the headquarters of the ICC Court of Arbitration is in Paris. But you could be having an ICC arbitration in Dubai, the United Arab Emirates. So if you put an arbitration clause, the model clause of the ICC, and select Dubai and the UAE as the seat of arbitration, the arbitration will need to pay close attention to the laws of the UE, especially law number 6 of 2008 about arbitration. Things that will be different from other jurisdictions. For example, law number 6 2018 sets a time limit for the duration of the arbitration, which is 6 months. So arbitrators should keep this in mind because certain things will need to take place if the arbitration lasts longer, right? Another thing that law number 6 addresses, that arbitrators will not be able to be members of the board of trustees or of the administrative bodies of the institution that appoints them. Yeah, you could be, if you are a member of the board of trustees, you're giving case to yourself. It doesn't sound very, very clean and transparent, right? So this law attempts to prevent that, such abuses. So it's very important that arbitrations stick to these laws of the place of the arbitration. All right? Why is important as well? For example, if during the course of the arbitration, any of the parties or the tribunal needs some measure, some help from the local courts, it will be the courts of the UAE of Dubai and not the laws of Paris if we had set an ICC arbitration in Paris, for example, in France. Why else is important? It's very important because the courts of the seat of arbitration are the only ones who could decide on the setting aside of an award. The award is the piece of paper, the judgment that awards sign, right? It's like a judgment in a court case. So the award can only be killed in the place where it is made, and it is made in the seat of the arbitration. So this is very important. Do not confuse the setting aside with the recognition. The recognition you can seek anywhere, and the party opposing the execution can oppose it anywhere. But you wouldn't kill the award. This can only be done in the seat of the arbitration. Also, do not confuse the law of the seat of the arbitration that governs the process and the governing law. For example, keep in mind that ICC clause in Dubai, UAE, the seat of the arbitration would be Dubai, but perhaps in the contract we have said that the governing law will be the law of the UK. So it will be the law of the UK that will apply to the merits. Who is right and wrong? what damages correspond to one or the other, if any, right? That's the governing law that governs the relationship with the parties. But the seat of arbitration governs or links the arbitration to a country. So it is more the relationship of the process rather than the merits, the substance of the dispute. I hope that this is clear and that you have learned a little bit with my video. If you have learned a little bit or you have enjoyed the video, please do like it. Subscribe so you can get to information about arbitration and legal affairs in the Middle East, and also how to build a career on international law. Thank you very much.